Okay, we will go ahead and get started, and I will call to order the Tuesday, January 30th, 2024 meeting of the Medical Records Requests and Records Fee Working Group. Um, I'll start off first by thanking you all profusely for your efforts here. I think this has been a great conversation over these many weeks, and I so sincerely appreciate all of you volunteering your time for this purpose. And I'm confident that we can come out of this meeting with something that everybody can live with. Um, but again, I think it's been a great discussion and great differing points of view on this, and just sincerely appreciate all of you being so willing to donate your time for this cause. Representative Conley?
Thank you, Representative Quinn. I echo the statements by Representative Quinn. I know folks from multiple states have taken time off from their days to join us on Zoom and to provide knowledge. I think I've certainly learned a lot about records um, and how records are being procured through the individual locations and the third party representatives. That I think getting that information out will be helpful and people to understand that these three statutes we talked about, although short in length, are complex in reality. Um, and how records are procured is quite complex from one location to another. So I know we did receive multiple proposals by multiple folks, and Rep. Quinn and I, along with help from Rep. O'Day, have done our best to provide a proposal that incorporates a lot of the recommendations or a lot of suggestions from different groups, and I hope to have a good discussion on that.
Okay, thank you. All right, first item up would be the approval of the minutes for the January 16th meeting. If I could have a motion to approve.
So move.
Second, Rep. Conley. Any discussion, changes, corrections? All right, seeing none, we'll proceed to vote. All those in favor signify by saying aye.
Aye.
Opposed? Motion carries. What I would like to do is divide the question here. I think that the two statutes are different enough because of the fee component that we should probably vote on the workers' comp statute proposed changes as one recommendation, and then the 20-7C changes as another recommendation. So without objection, I would like to do that, and I would first ask for a motion to accept the proposed changes to CGS 31-294F, which would be the workers' compensation statute.
So moved.
Is there a second?
Second.
Okay, discussion. Again, the main change that we made was just beefing up the penalty provision if there is failure to provide the record within 30 days, excuse me, the report within 30 days of its completion. And we feel that in many circumstances, just a letter from the judge indicating that a report has not been received as a first step makes a lot of sense and will probably solve most of the delays and would not lead to the imposition of the third prong, which could be a fine of up to $500. Generally, we left the statute alone, except for making that change at the end. So I'll open it up for discussion, and Susan, you had your hand up first, so we'll have you go first.
Thanks so much, Representative Quinn, Representative Conley, and everyone else on the medical working group. So I do want to say that as it's written now, the entire C section that's proposed is not something that the Orthopedic Society can support. And we had submitted on the 19th of January a proposal of recommendations that we thought would be helpful for both improving the timely receipt of records of workers' comp patients, as well as working with the workers' comp commissioner and their and his staff to work through this issue. So we did submit those on the 19th, and that is something that we could definitely support. And then just as a side, under B, even though there's no changes being proposed to section 1 to section 3.129.4 FB, I would just propose that last line where it says to the employer and the employee or his attorney, I think we might want to make that gender neutral.
Yes. Why don't we offer that in terms of a friendly amendment, and we'll start with that one first to change the word his to their in the last line of section B. Motion by Susan Schaffman. Is there a second?
Second.
Any discussion on that amendment?
I just think,
Yes, go ahead, Kathleen.
sorry, thank you. If you're going to be consistent, the gender neutrality should sort of carry through that whole statute. So if you look in part A and part B, there are several references to his or him. And so I think if Susan will accept sort of a friendly amendment, I would say the entire statute should be made gender neutral.
Yeah, I would agree with that.
For the full amendment.
Okay, so the amendment would be to change all single sex references in 31-294F to the gender neutral of their, assuming that the word fits the sentence. Any further discussion on that proposed change? Then seeing none, we'll take a vote on that proposed amendment. And Nate, if you want to call the roll on that.
Bristow, or do you want to roll?
Pardon?
On the amendment, you want to do a roll call vote? Or
Yes.
Okay.
Yeah.
All right, Rep Quinn,
Yes.
Rep Conley?
Yes.
Mike D'Amico,
Yes.
Rep O'Day,
Yes.
Senator Anwar, Jennifer Cox,
Yes.
Senator Summers, Kim Schlottman,
Yes.
Marie Gallahall,
I'm abstaining from all votes.
Kyle Probst,
Yes.
Wiz McKelney,
Yes.
Rick Silver,
Yes.
Rachel Pattison,
Yes.
Kathleen Nastry,
Yes.
Carl Schissel.
Thank you for calling my name. I think it'd be appropriate now for me to ask a procedural question about this roll call process and vote, if allowed, or I'm happy to abstain and we can talk about it later. Shall I proceed?
Your question is definitely in order, but we're in the middle of a vote, so I think we should finish the vote and then take up your question.
Great, so I'm going to abstain.
Wayne Gakos,
Yes.
Stu Schaffman.
Yes.
All right, Mr. Chair, that's it. You want me to announce the tally or no?
Yeah, go right ahead.
Okay. $13 voting, 13 yeas, 0 nays, 2 abstains. The motion passes.
Okay, thank you. That amendment passes. Continuing the discussion on 31-294F as
Mr. Chairman?
amended. Go ahead, Carl.
Yeah, thank you for indulging me. Served on a lot of working groups and task forces, some that are ongoing, some statutory, some sessional. It's unusual in my experience, for us to be taking roll call votes during these sort of informal work group meetings, essentially when the charge to this group is to develop legislative recommendations and to report them to the Committee on Cognizance. So since this is something that's new to me, I did want to ask a procedural question, or at least one procedural question. The Public Act provides for the appointment of 17 members of this working group. And while we've had very good participation and attendance over the course of this process, several of us have had to miss meetings from time to time. And so my question relates to these roll call votes. In order for a motion to carry in this working group, does it require a majority of the full working group, which would be 9 votes, or is it a majority of those present and voting?
I would say a majority of the membership, so 9 would be my ruling on that.
Mr. Chair, I would
Yes.
say our usual procedure is that as long as we have a quorum present on committees, the majority of those present. I would ask you to entertain that.
Okay. If that's the normal procedure, then that is fine with me, and that's what we'll do. So a majority of those present, we have 15 present, so 8 would be a majority of those present.
So Mr.
That's my understanding as well. Thank you.
Thank you.
So, Mr. Chairman, in the absence of any clear guidance in the joint rules or the House rules or the Public Act, I think it's appropriate for the working group itself to decide what its rules are going to be. And obviously, you've taken a position which I think is a reasonable one. But in the absence of any clear guidance, how we do it in committee, how you do it in the floor or in the chamber, isn't what we're talking about here. We're talking about a particular public act that doesn't necessarily have a whole heck of a lot of procedure. I'm also, and so I'm quite comfortable letting your ruling stand and recognize the corollary procedures that you're citing to. And frankly, it isn't as important to me to know which way we're going to do it, but exactly how we're going to do it for purposes of completing our business today. The other thing I wanted to put on the table as we entertain these roll call votes is the question of how we marry the results of these votes to our obligation under the Public Act to submit a report on our findings and legislative recommendations to the Judiciary and Public Health Committees. The purpose being, in most working groups I've been on, especially sessional ones, there's a report that includes a pretty full treatment of what's gone on over the course of the work group, not just, let's say, a roll call vote with a version of a JF report that says, here's what we voted on and here's who voted how. I think the fundamental purpose of this working group is to inform the 2 committees of cognizance, but also the entire General Assembly, and frankly, the advocacy community, including those individuals who might have an interest in any of these issues who are not otherwise represented on the work group because they weren't included as an appointed authority in the statute. I recognize that they can watch CTN and see the meetings, and they could even, get permission to perhaps join as a guest. And I recognize too that at the end of the day, this work product is essentially intended to inform the legislative process. So I wanted to get a fuller understanding about how these votes fit into the bigger picture and what the expected work product of this working group, is going to be going forward. I appreciate your indulgence and I look forward to our discussion. Thank you.
Okay, thank you. Then we'll continue on with discussion on 31-294F as amended.
I believe Susan had the floor, Mr. Chair.
Correct. Susan?
Thank you. Thank you, Representative Connolly and Representative Quinn. So as proposed in the medical records recommendation, the Connecticut Orthopedic Society can't support this. And the reason being is that we are still trying to really get to the heart of what the issue is. We had the opportunity to meet with the workers' comp commissioner the other day, and some of his staffing to try to determine where the real issue is. Is it medical records? Is it reports? What reports are they? Are they the initial report? Are they progress reports? Are they narrative reports? And so that's why we wanted to bring it back to the Workers' Comp Commission and bring it back in the proposed recommendations that were made to this work group on January 19th. I know that it has been, we have been told that there are some institutions that are frequent flyers, if you will, for these extended 30 days of medical records and reports. And I know that we can address that separately. So I don't think that this amendment as proposed would address the issues that are currently being experienced.
Well, what thoughts do you have differently then?
So when we had proposed recommendations, I worked with the Connecticut State Medical Society and Lane to really try to offer educational initiatives to the physicians and the attorney community, the legal community, to remind everyone what the reports are, what the components of the reports are, and how to transmit them most efficiently. The other thought we had was to explore a technical solution so that these reports and records could be directly transmitted to the Workers' Comp Commission. So I think if we had those opportunities to explore that while educating and just offering refresher courses, if you will, to the physician community and the legal community, we may be able to address this without punitive, as proposed in the recommendations that we're considering, this working group is considering now. And the other part of it too, I think a little concern is that I know one of the institutions is UConn, that there's been some issues with timely reports and records being received from UConn. And I'm just wondering how those fines will be assessed to the UConn physician community and UConn as a health facility as well too.
Well, I mean, the fine is left up to the discretion of the workers' comp judge. And also, I mean, I guess I can't understand a set of circumstances where it would take more than 30 days after the report is completed, not the visit, but after the report is completed for it to be disseminated. So, it would seem to me that if the 30 days after completion is not deemed to be sufficient time, then what would be deemed to be sufficient time? It would be one thing if we were saying, okay, the visit happens on January 1st, you've got until January 31st to have a report in the requester's hands. That would be one thing, but 30 days after it's completed, I just don't know what possible delay there could be after completion unless it's a transcription issue. And to me, if there was a transcription issue, that would be a defense for the tardy medical provider to make that, hey, I did the report. We had an issue with the transcription service, and that's why it was delayed.
And I guess coming back to what you're saying, Representative Quinn, is that it's still really hard for us to get a good grasp on where the issue actually is so that we can have a really good solution to address that issue. I will tell you that the Connecticut Orthopedic Society representatives that I've spoken with and that we've talked to, the Workers' Comp workers' comp commissioners have all said that 30 days is enough time. And that they also say that if the physician or facility is not submitting those reports within a 30 days, then perhaps they get excluded from the participating provider panel for workers' comp. So that was one suggestion that was made.
Would you think that we should add that then as a fourth item under this section?
I think that if you wanted to just include a letter, right? That could be one form of communication from the administrative law judge to the physician, of a letter that they're tardy. And that in that letter, it could be something that is explained to them that if this is something that reoccurs, or if the workers' comp chairman deems so, that that provider would not be able to do workers' comp anymore.
I mean, I think that we have made this worded it as to show the most discretion as possible, because I mean, penalties may include, not shall include, and the first one is that letter, which I would think that unless it's a situation where this has been an ongoing issue with a particular provider in a particular claimant's case, that that would be the route that most, if not all, administrative law judges would go, that they just wouldn't immediately go to the fine aspect unless it's been somebody who has been a problem. You know, I mean, my feeling is there needs to be some sort of financial penalty as an option, just so that there is some teeth to encourage the providers to provide them within 30 days of the completion. But I certainly don't have a problem with changing it so that it's more of a last resort, if that's something that could be found to be acceptable.
Yeah, I mean, I would like to hear some other people's comments, if you don't mind.
Yeah, no problem. And don't think I'm picking on you.
No, I don't. I don't think that.
Okay. All right. Jennifer, you had your hand up first.
Thank you, Representative. It's interesting. We had a couple meetings where, in particular, I recall Representative Conley making really good points that for those of us that work on the legal or administrative side of providers, we were surprised and a little bit chagrined, because I will tell you, despite the fact that while you apparently are doing workers' comp legal work, you feel the impact. We did not know this was happening. We have moved swiftly, as Sue was saying, to try to make amends for this and try to make the system work. It seems like a lot of pressure to create that might be entirely unnecessary, to have a very aggressive and threatening statute when all the provider groups on this call in several meetings and right now are willing to do what it takes to clean this up. Also, we have a little bit of a problem when we are trying to legislate administrative law, right? So you can't give a fine without hearings. That's going to put a lot of weight on workers' comp. And workers' comp does not have a lot of authority over these providers right now. And I think, and I said it previously, I think you will find people dropping out of workers' comp, which is not the result you want, because of the hassle factor. So workers' comp has the ability to send an unhappy letter or a warning to anyone right now. We're going to start having fines and penalties for something that administratively was unknown to the people that helped make the trains run on time. It just seems like overkill, and it'd be difficult from a public health hospital perspective to support that type of penalty when we have not had an opportunity to fix it.
Okay, thank you. Marie?
As you know, I'm not commenting on
what's good or bad. I'm just raising some issues for consideration. One of the things that Susan mentioned about the chairman maybe being able to include something that says they may lose their ability to practice in the system, and that dovetails with something that Jennifer just said about providers maybe dropping out of the system. The chairman already has that ability to tell providers you're not playing by the rules, so to speak, and we're not going to allow you to be part of a managed care plan or participate in the system. However, he does that, he doesn't do that very often. And the reason he doesn't do that very often is because we have a real lack of provider problem in the system. As many of you know, a lot of the big practices have bought each other up. There's less and less doctors who are willing to participate. Psychiatrists, neurologists. There are certainly certain aspects of the profession where it's difficult to get enough doctors to see the injured workers. So I just want to put that out there as consideration and something for this group to discuss. The other thing that Jennifer mentioned, which I just want to reiterate, she's absolutely correct. Fines need to go through a formal hearing process. Judges just can't be issuing fines, left and right at their will. It would have to go through a formal hearing process. And I have no idea of how many formal hearings that would generate. So that's just something for your consideration as well.
Okay, thank you. Rep. O'Day.
Yeah, I was just listening to it. What if we didn't have a fine until after 1 and 2 happened? So after a letter and after a hearing, then the administrator may assess a fine. And if the fine were reduced, would that if we put in those 2 changes, would that satisfy the concerns of those on the call now? Just a proposal. It's an idea.
Yeah, no, that's an excellent point. Rep. Conley?
So I just wanted to share something that happened after our last meeting, is that the chairman's letter from 2019 that was sent to a lot of providers got recirculated around. So I understand, I really appreciate that folks on this call didn't realize that the record statute might have existed, or the record problem was a problem, and are swiftly working to correct it. And I appreciate the swift work to correcting it. But the chairman in the bar, all sides of the bar, have been aware of this problem for quite a period of time. In the good chairman did in 2019 send that letter to everyone about the problem. And here we are in 2024 discussing it. I would say again, but I want to be respectful for some people who I know are making good change, discussing it for the first time. I want to be clear, it was not the intention of myself or of Chairman Quinn to ignore a proposal to have the chairman continue to work with others. What it was, the intention was not to legislatively force an administrator to set up a working group by this working group. If the chairman wishes to continue, and I know many of us know the chairman is open to working with many, but I don't think it's the place of this working group to legislate or to make a law requiring the chairman to have another working group. But I do hope if folks do come with any resolutions or any suggestions or work with the chairman or others, that when this working group's work, which hopefully will be presented to the Committee of Cognizance after today's meeting, that as bills come through, they can of course be addressed, changed as to what others have said after public hearing, and nothing we do today would become law at all. It's just a report to the committee. So if the associations who have concerns are able to address those with members of this group, members for the general public, or with the chairman themselves, I don't want to say that that's not something I don't encourage or discourage anything we propose if new information happens in legislative session can certainly be and should be addressed. I'm hopeful that this will not, there will never need to be a formal hearing on a record not being received, because functionally, by the time you get to a formal hearing, we're probably a good 4 or 6 months from when the issue was raised that the record's not there. And I would hope that the letter that this record isn't here would cause whatever institution that may not have been aware of the problem to what some institutions are doing since our meeting 2 weeks ago, to figure out what happened in their policies, what happened in their strategies, and correct that issue. Everyone's goal is for the records. No one's goal here is the fine, which is why it's a may, and why there's other alternatives, which while the judges were giving full discretion in this statute, I would think the judges would choose the first thing, because that's what they choose in workers' compensation on other areas. When someone fails to attend a hearing, the no-show letter comes out first, not the fine. They have the authority to fine in the statute. They've always had the authority to fine, and they can even fine UConn in the statute. But what the good judges are doing is they are sending the letter of, hey, you're supposed to be here. Can you correct your policy? And 9 times out of 10, that correction is what happens. So since that's what happens in the bar and with the judges, I would expect the same thing to happen with the medical records. Right now, we have an issue of a long-standing statute being around, and I understand people were unaware, and it's not being followed by everyone. It is being followed by many, though. I want to be clear. It is being followed by many, but not everyone. And there's no penalty for the judges to get correction, whereas in other areas of the law, there is a penalty. And I do hope that the letter will solve most of the issues. I hope there doesn't need to be a fine, because again, that means we're at hearings and it's been months and months, and no one's had their records, which is not the purpose of the process. So again, if no one ever needs a hearing on this issue, I think it's great. But there are other sections that do have the penalties. The judges cannot award penalties outside of formal hearings. They can cite people in, they can have these discussions. And if there's a better solution after this committee reports out, I'd love that to be amended and worked on.
Thank you. Anyone else before I throw something out there? Okay. How about this for wording? Change the wording to, in the event that a report is not received within 30 days of its completion, then the administrative law judge shall send a letter to the provider informing them of the delay and requesting that the provider provide the requested reports within 15 days of the date of the letter. If the report is still not received, then the administrative law judge shall hold a hearing to ascertain why the report is delayed. If the administrative law judge finds that the delay is unreasonable, then the administrative law judge may impose a fine of up to $500.
I know Marie would raise her hand on that.
Go ahead, Marie.
I have some concerns with respect to an increased number of hearings and an increased amount of work when you change the word may to shall.
I have no problem with the word being may. Jennifer?
At the risk of repeating, what you're going to get is people dropping out of comp, and that is not what anybody wants. And the hearing is going to still be required because the providers are not parties; they are participants under the workers' comp plan. So, I don't think it fixes it. I have faith in the Workers' Comp Commission that it has the tools it needs, and for the reasons I assume resource related, has chosen to go about it this way. So I do not think a legislative solution that has a penalty is going to get the result you are seeking.
Well, I mean, I think quite frankly, any provider who finds themselves in the position of facing a fine is probably somebody that we don't want in the system anyway, to be to be frank about it. You know, I mean, I just think that at some point in the process, if there's a continued delay and no reasonable explanation for why the delay is happening, and I mean, we understand, I mean, doctors go on vacation, that creates a delay sometimes. You know, depending on whether they have someone in their office doing the transcription or if they've got an outside service doing the transcription. I mean, we understand that there are issues there too. I mean, I just think that at some point in the process, if every reasonable step to get the report has happened and gone through and we still don't have a report, then some sort of penalty is in order. And again, I mean, it's not every provider, but it's becoming more of an issue. And again, I mean, it's not every provider, and the majority of the providers do everything appropriately. And since they do everything appropriately, this would never be an issue for them. So, anything else you wanted to add, Jennifer?
Nope, thank you.
Okay, thank you. Lane.
Hi. So I just want to echo some of what Sue and Jen have said. I think the reality is you're right. There's not many physicians or providers that are going to face this fine. But the fact that a punitive statute even exists and the possibility is out there is going to discourage rather than encourage providers from entering the workers' comp system. And that's the opposite of the impact that we want to have. We need more providers, more physicians in the system, and not wording that will disincentivize them from being workers' comp providers.
Okay. Thank you. Anyone else? I mean, I think that 30 days is sufficient. I mean, does anybody think that 30 days is not sufficient? That it should be a higher number? Okay, any further discussion then? We will, Rep. Conley, did you? Okay, thank you. All right, yeah, Rep. O'Day.
Just real quick, if anyone who was concerned about the fine, is it the amount of the fine? Is anybody, would anybody feel better? Or I'm just thinking if we lowered it, or I don't know. I'm just trying to think out loud to try and accommodate some of the concerns about the fine. I think your suggestion is a good one, that it would happen only after a letter and a hearing, but is it I don't want to discourage providers, but at the end of the day, we do need some teeth in if they just ignore it. But just some thinking out loud, is it the amount? I mean, do we lower it 100 or 200 or I don't know.
Yeah, no, I mean, I agree. And I'd be happy to hear anyone who has an issue with the fine as currently composed, if a different number could work.
I'd be happy to entertain that as well.
Sorry, Chris, I didn't hear that.
I said I'd be happy to entertain for those who have objection to the financial penalty if a different financial penalty ends that objection, but I did see some head shake no. So if folks are hearing it minutes, I think they did speak up with a shake in their head that they have an issue with the actual fine, and a changing of the number wouldn't resolve that concern.
I mean, I would think, quite frankly, that the associations would want their medical providers doing things in an appropriate fashion, but I'll just leave that there then. All right, if there's no other comment or question or discussion, then we will proceed to take a roll call vote. And Nate, if you could call the roll.
Is this on the section as amended by Amendment A?
Correct.
Rep. Quinn,
Yes.
Rep. Conley,
Yes.
Mike D'Amico,
Yes.
Rep. O'Day,
Yes.
Senator Anwar, Jennifer Cox,
No.
Senator Summers, Kim Schlottman,
No.
Marie Gallahall, Kyle Probst,
No.
Liz McKelney,
No.
Rick Silver,
Yes.
Rachel Pattison,
Yes.
Kathleen Nastry,
Yes.
Carl Schissel,
No.
Wayne Gakos,
No.
Sue Schaffman,
No.
Nate, if you can announce the
Yep.
tally.
total voting 14, yeas 7, nays 7, abstains 1, not absent, not voting 2. The motion fails.
Thank you. Okay, then we will move on to the second part, which would be proposed changes to 20-7C of the general statutes. And to start it off, if I could have a motion to approve.
Oh, so moved.
Second?
Second.
Okay. Discussion.
I could start if you'd like me to.
Sure, go right ahead.
So first of all, I just wanted to say that I greatly have appreciated the opportunity to have served on this working group and to have met all of you, even though it has been by Zoom, and to have heard and learned from all of the different perspectives. And Chairman Quinn and Chairman Conley, I did want to also thank you for the difficult job that you have, because listening to a bunch of different perspectives and trying to cull them all down into a framework to move forward is a challenging job. And so kudos to both of you for the hard work that you had to put into this to get it to where it is right now. I did want to just say a couple of things. There is a cap on the electronic records amount, and I don't know that it was something that anyone wasn't aware of, but that cap amount is the highest cap amount that I'm aware of anywhere across the country by quite a bit. Then the only other thing that I wanted to mention was the provision for the expedited record seems to be something that is almost optional as opposed to mandatory. In other words, if it's requested that it has to be followed, and so it seems like it does need a little bit of teeth. But I can say that this is a big step in the process moving this forward, and I think that both of you have done a great job, including the input of Representative O'Day, I understand, as well, in putting this proposal together. And so we look forward to continuing the process, to continuing to work with both of you and both chambers, and hopefully a signature by the governor. But this is a big step forward, and we wholly support it. I wholly support it.
Thank you. Rep. O'Day.
Yes, thank you. And thank you, Mike, for the comments. And I will say, Kyle, I very much appreciated getting the information to whoever else provided it on what was going on around the country. I don't want medical providers losing money on providing medical records. And so I will say that maybe I was a bit of a push to make the fee higher. on the electronic version, because I want to make sure that the hospitals are not losing money on compiling this information, particularly on from the defense side, from where I generally sit. But we did take into account the information we got from across the country, and I think this is a measured step towards doing something that's fair for everyone. So I'm looking forward to hearing from Kyle and the hospital representatives. Thank you.
Thank you. Further discussion. Kyle.
Thank you, Representative Quinn, and thank you everyone for taking part in these discussions over the last several months. I want to say that I've had an opportunity to work in a couple of states where we've had week-long or month-long discussions in a work group setting, and I feel like we've been very open with each other and willing to listen to each other and hear all sides of the story and consider all evidence. And I really appreciate that. I appreciate everyone's willingness to come forward and learn about this issue rather than just, pick numbers out of the sky and, come up with something that would be forced on one another. So I just wanted to say that first of all. That being said, I do appreciate putting forth the CPI adjuster in the proposal and the expedited fee. I think those are very important elements. At the same time, though, I have to look at what our current business model is like and what the current request level is like and the current fee structure is like. And these fees were adopted in 1993 and have not been adjusted since. And since 1993, we've had the adoption of HIPAA, we've had the Cures Act, we've had a HITECH Act, we've had the implementation of electronic health records across the great majority of providers, which for the most part are not interoperable and still require a lot of labor hours in order to retrieve records. We've seen that requests are as difficult as they used to be as far as interpreting those initial documents when they come in, whether it be estate documentation, administrator documentation, powers of attorney, subpoenas, court orders, standard authorizations or non-standard authorizations that are drafted as one-offs by individuals. So there's a lot of work that goes into making sure that we are not breaching patient privacy. And when I just did some research going into today in preparation for this, and I just want to say, here's some numbers that I pulled from 2023. Connecticut is the 9th most expensive state in which to live. It has the 4th highest minimum wage law, just behind California, District of Columbia, and Washington State. And it is one of the lowest medical record reimbursement rates in the country. It and New York are two of the only states that regulate fees that do not have a search and handling fee. And New York adopted its law in 1991. So when we look at that, 1991 was New York, 1993 was Connecticut. They probably influenced each other's legislatures in that process, if not directly, at least by having some kind of outstanding precedent. And I pointed this out before, that when we take the 65 cents per page that's in the law now, and we do a CPI adjustment using the U.S. Bureau of Labor and Statistics CPI calculator, that 65 cents becomes $1.40 a page in 2023 numbers. So I'm not, again, and I said this when I introduced those numbers before, I'm not suggesting that we have a $1.40 per page fee, but to do anything that would be less than the 65 cents is really going backwards, considering that was established in 1993. And I'm very sincere when I say I do appreciate including the CPI adjuster in the statute, but isn't it kind of counterintuitive to say we're going to set the standard lower than it is today, but we will acknowledge that a CPI adjustment is necessary, but only for the future. So therefore, a couple years from now, if CPI continues to increase, which it could decrease, by the way, but if it continues to increase, you'll eventually get to the rates that you're allowed to charge today. And that just doesn't sit right with me. We went into this hoping that we would be able to get some kind of a search and handling fee for the initial validation of all the request documents and the initial work that's required before we even start looking at the medical records, so that we be consistent with the majority of states that have, again, an average of a $24 search and handling fee. And this proposal does not acknowledge that. So those are my comments for today. Thank you for the time, Representative Quinn.
Thank you. Anyone else? Repo Day.
Yes, so just real quick, I have a recollection of discussing a third-party fee for third parties, but what is the number, in looking at what other states charge, what's the number that you would like to see on a per page basis? We looked at Illinois, which we thought was on the higher end, but I want to hear what you would suggest.
I think we put forth, and again, I don't believe it's just up to me. I do believe we have an AHIOS group, which is the association that represents the information matters. I also believe the providers have a stake in this as well, as many providers, especially small practice groups, do have a lot of practice groups that produce these records on their own. And if the fee isn't adequate for them, that puts additional strain on them as well. So we did put forth a proposal early on that I would stand by without going back to the group and asking them again for a confirmation of what number would be appropriate. And I believe that proposal, which we should all have, I'm trying to recall from memory, but we increased the paper rate, and then I think the electronic rate went to 60 cents a page, I believe, and then we had a cap on it. So it would actually be 5 cents a page less. But we had the search and handling fee in there as well for, I want to say we had proposed, I believe it was $25.
Repo Day, does that answer your question?
Yes, I remember having a conversation of having a search fee for third parties. Can we, and I'd be happy, I would defer to the chairs, but as someone who is often representing the third parties, defense counsel and insurance companies, I'm fine with putting a $25 fee on third party searches as opposed to the patient and their representative. I don't know if that's something that the chairs are amenable to, and as far as the per page cost, Kyle, I think to point out, I mean, you agree that we've got the highest in the country for digital records. And I thought we've got one of the highest for print as well. Is that true in the proposal?
No, these are not the highest fees. They're some of the lowest fees in the country. 65 cents a page is one of the lowest. I mean, just your neighbor in Massachusetts is over $1 a page. I believe Rhode Island is $1 a page down to 50 cents a page after, I think, 50 pages. New York is at 75 cents a page, but again, that was adopted in 1991 and should, I'd like to increase that. New Jersey is $1 a page. Pennsylvania is over $1 a page. Those are all states within your region.
Okay. All right. Thank you. Elizabeth.
Geez, you'd think that, a couple years after the pandemic, I'd be used to, taking myself off mute. But thank you, Representative Quinn and Representative Conley, for the opportunity to participate. I really appreciate the dialogue that we've had with everyone in the work group. I just want to bring up two things. The first is I agree with Kyle about the CPI adjuster. I think that that's great, and I really appreciate you putting that forward. I won't go into the individual per page fees and referencing the cost of business and living. I doubt that I could do that more eloquently than Kyle just did. So I will leave that with him. One thing I did want to specifically talk about was the lack of a search and handling fee. And that's because not only for companies, but also for the providers, be they physician groups or hospitals, you have to respond to every single request, whether or not it's valid. You have to validate to make sure it's HIPAA compliant. If it's not, you have to return it. And then that process, does take labor. It costs to generate a letter and send it out if you opt to do that by mail. If no records are being generated, the providers and third parties would be asked to foot that bill. They would actually be losing money. So that is something that, one thing that I think that we need to factor in terms of, having a search and handling fee along with the per page fees. And one thing that, I did want to speak to you about the expedited fee that Mr. DeBico had brought up. I appreciate the desire to have an expedited, fee. And I think in most cases, providers or third parties, could most of the time, in my thoughts, would be able to accommodate that. But I think that we need to make sure that it's not mandatory, because there are going to be situations where perhaps, we have a pandemic, it's a seasonal flu, or, an EMR is down. We have to accommodate for that, those kind of extenuating circumstances. So I wouldn't want to require providers to be able to turn that around in that time frame when there could be some circumstances beyond their control. And that is what I have for the moment.
Okay. Thank you. Mike.
So I did want to say, and perhaps I was remiss in not saying this initially when I was commenting, that I did notice that the only time there was a search fee provided in this draft was in the event that redactions were requested. And that limitation on the search fee is certainly key to my support to this. We don't want to be in a situation where we have records that are requested, which we often have to do many, many times throughout the life of litigation. And there are 2 or 3 pages being provided. And there's a $25 search and handling fee every single time. That's a big problem. So that I saw that as juxtaposed with the much higher cap on the electronic records. I didn't know if there was some quid pro quo there, but I looked at that and I said to myself, well, this is a much higher cap than I would have anticipated, but I do notice that there is not a search fee every single time there's a request for records. So that is key to my support. I also wanted to mention, albeit it was a rough average, I did, and I think I mentioned this a while back, try to average what the per page fees were on paper records for the states that have those. And the average that I came out with was 54 cents a page. Now, it's a little bit of difficult math because of the tiered system, similar to what's proposed in this draft, where you have the first number of pages at X amount and the next number at X amount. And so when I had states that were in that tiered system, what I did was I took the average of those tiers. And then that was the average I used in the state when I was doing my calculation. think I also mentioned that Staples charges 20 cents for black and white, 20 cents a page for black and white copies currently, based on what I see. So, I don't see the issue with the per page fees as being something that is too low. There are also states that have a cap, by the way, on paper copies. And I also noticed that in this proposal, there is no cap. And that was something that I know that Kyle had mentioned throughout the course of the meetings. So as I said before, it's a challenging job to put together a proposal that gives appropriate consideration to the differing perspectives. But in the end, this proposal is a good proposal. It's a good and a big step forward, and I support it.
Okay, thank you, Rachel.
Hi, everyone. Let me lower my hand quickly. So, yeah, I echo what Elizabeth said. You think I'd be used to Zoom at this point, but I think I might have clapped earlier rather than raise my hand as I intended. But I would also like to say thank you. It's been such a pleasure to meet with everyone and work with this group, and I appreciate all the input. I've also learned a lot. I just wanted to say I am concerned about the consumer price index wording. I think there's been so much discussion in this group alone about increasing rates or increasing rates. And I think the legislature should be the body to review and determine the need for a change as opposed to an auto increase or decrease. I am concerned about a per request fee also. I think it could cause a request for a small amount of records to increase substantially. So I am against a per request fee. Thank you.
All right, thank you. Jennifer.
Thank you, Representative. Everyone's been very generous appropriately in thanking you for this forum. It is particularly interesting to me since this is what I do most of the time and no one ever wants to hear it. And now I get to talk to people. So I extra appreciate that. I think the CPI adjuster is helpful because then you're not stuck having to come back, although I understand the different views on that. I want to point out something that came up earlier in these proceedings, not today, but in earlier meetings. In Public Act 2397, Section 43, last year, Public Health Committee put through an important piece of legislation about expediting records specific to care and treatment. When an institution is going to transfer records or share records with another institution within Connecticut. And why I mention this, again, is that in that statute from last year, the expedited time frame for completing that record transfer between institutions after a patient-directed request is 6 days if it's urgent for care. You can't expedite everything because if you expedite everything, nothing is expedited. That law, 2397 Section 43, has only been in place for 29 days now. We don't have enough experience with it to see if it is going to displace any of the resources that are needed. That's my first point. Second point is, if the third-party vendors don't support the fee proposal, and I heard that they did not, that it is not working, the math doesn't work, that is a big problem for hospitals and institutional providers who rely on them, because if the third-party vendors are not there, there will be a hard cost to the healthcare system overall, having to resource what is now being resourced by an entirely alternative method. Not to mention that the smaller providers will have to absorb that cost on their own. So Representative Day appropriately said he wanted to hear from the hospitals and providers what they thought. And I will tell you that if the third-party vendors say the math doesn't work, then it's not something we can support because it will eventually regurgitate back on the healthcare providers to have to fill that gap. I do think there should be a mechanism for expedited records, even though it shouldn't jump the line on care and treatment, for all the reasons that the litigators have mentioned throughout this process. We the hospitals put in a proposal that would have a pathway for expedited to cut the time in half with an expedited fee, which seems like a good balance. Everyone gets something of what they want. That's not how this proposal ended up, I understand, but I get that concept, but it can't be more expedited than an urgent request for care, as in last year's 2397. Additionally, I'm not sure the HIPAA language is exactly right. It would make sense for the state of Connecticut to update these laws. That is something that I've agreed with the trial lawyers on a couple of times in this process. But if you're going to update these, you got to go soup to nuts on aligning with HIPAA in the first place. And this doesn't exactly align with HIPAA, which will cause confusion. I appreciate you letting me comment. Thank you.
Thank you. Kyle.
Thank you, Representative Quinn. And I just wanted to, if I may, inquire about another part of this bill to see if it's being considered at the same time. I believe it is, but I just want clarification if I could. There is a penalty provision in here as well of, I think if a record is not delivered within 30 days, there's a 50% penalty, and then it goes up from there. Is that being considered at the same time as the fee provisions, Representative Quinn?
Yes, as we
Okay.
have it before us, all of the proposed changes to 20-7C are what we're currently considering.
Okay, so if I may address that for a moment, there are no provisions for consideration or leniency there, and I don't know how that fine or penalty is to be determined other than between the two parties working it out amongst themselves to say, I'm only going to pay, say, 50% of the fee that you charged me. And I also would like to bring up that there are instances where I'll use the term force majeure that I'm sure you're all aware of, where we may not be able to access an EHR. We had a large health system back in 2023. It was in August. It actually made some news on this. Their EHR was held by ransomware, and they had to shut down. And they would bring up hospitals and health systems within their national network periodically. It just so turns out Datavant was their release information vendor. I should say is their release information vendor. We still are. And we were not able to fulfill requests for this entity, this covered entity, for a period of 3 months for some of their facilities. Some of them we were able to get back up and running, and it wasn't a breach of our security, it was a breach of theirs. And so we were left really unable to access their EHR due to this ransomware attack. And so there's nothing built into this language that would provide a scenario like that where you're unable to access the EHR for your routine work. So now, worst case scenario, like I said, we had some facilities that took them 3 months to get back up. You're beyond the 90 days here. And there's absolutely no language to cover that or to cover how the reduction in fee is to be. Are we supposed to just look at our invoices and say, okay, well, we're going to have to reduce this one voluntarily? What if we have an argument as to why it shouldn't be reduced? So I think that the language is a little lacking there. I join with the hospitals in the sentiment they expressed regarding the penalty provision under workers' comp as well. I think we need to look at what is the problem we're trying to solve, and is the hammer the best approach to this? And if the hammer is the best approach, then what exceptions should we carve out? I don't think it's sufficient to just simply put the penalties in the law. And regarding the search and handling fee, I know this is just anecdotal, but we have landscape lights at our house. And the other day I had a landscape light that went out. And when I called and asked the company who installed those lights, the company I've had a contract with now for 4 years, and I said, could you come out and take a look at these lights? They said there's a $125 service fee just for driving into my driveway. And I said, well, does that go towards the entire fee? They said, no. Well, no, that's just $125 fee just for visiting your property. So it is not uncommon, and I'm sure everyone on this work group has paid a fee simply by asking an entity, a commercial entity, to look at something and see if there is any work that needs to be done. And that's what you're essentially doing when you send us a medical records request. You're saying, please check your files and see if this patient's file is in here, if you have any medical records for this person. And what we requested was simply a $25 fee for that. So I just want to let everyone know that's not unusual in other areas. So thank you.
Thank you. Lane?
So hi, I just wanted to be the voice of the smaller provider office for a minute and recognize that if we're talking about the per page handling fee, if 65 cents was appropriate in 1993, the average number we're talking about now, however many years later, in order to cover the costs in those offices, it has got to be increased. I mean, we're looking at everywhere that the provider offices have costs and where they're getting hit. Medicaid rates are going down. Medicaid rates are staying stagnant. Medicare rates are going down. Commercial payers rates are going down in many instances. These offices are barely hanging on. And if we're asking them to take a hit every time that they have a medical record request and essentially lose money by utilizing their staffing to pull these requests, these offices aren't going to be able to survive. And I'm not saying that medical records alone is the linchpin for that, but when you look at the totality of everything that these offices are being asked to bear, it makes an impact. So I think we have to look at either a search and handling fee or the higher per page rates. I recognize that someone had floated the number 54 cents per page on average, but I'm not sure that that includes search and handling fees, which a number of states have. So I just wanted to put that out there.
Okay, thank you. Anyone else?
I'd just like to say, how
Sure,
long
go
are we
ahead,
gonna
Rick.
go? How long are we gonna go, Mike? Because I have a medical appointment at 3:30. Are we going to be done by 3:30?
If nobody else has anything to say, we could be done in about 5 minutes.
Okay, I'm hanging on.
Okay. All right, any further discussion? All right, seeing none, Nate, if you would call the roll.
Rep. Quinn,
Yes.
Rep. Conley,
Yes.
Mike D'Amico,
Yes.
Rep. O'Day,
Yes.
Senator Anwar, Jennifer Cox,
No.
Senator Summers, Kim Schwatman,
No.
Marie Gallahall,
Jane?
Kyle Probst,
No.
Liz McKinley,
No.
Rick Silver,
Yes.
Rachel Pattison,
No, because of the CPI.
Kathleen Nastry,
Yes.
Carl Schissel,
No.
Wayne Gakos,
No.
Stu Schaffman.
No.
And if you would announce a tally.
Total voting 14, yeas 6, nays 8, abstains 1. The motion fails.
Okay. Thank you very much. Okay, well, that concludes our working group. Obviously, I had hoped that something would have come out of this, and I'm a little discouraged that there weren't any proposed amendments for changes that folks would have liked to have seen that perhaps we could have reached a consensus on. But in any event, it does not diminish from all of the effort that each and every one of you has put into this. And again, as I said at the beginning of the meeting, greatly appreciative of you volunteering your time. And, you know, it means a lot to myself and Representative Conley to have such devoted people in Connecticut who are willing to get involved like you did. So again, thank you very much. Any final remarks, Rep. Conley?
Thank everyone for their participation. And if committees have every right to raise whatever they feel is appropriate this year, I hope that these issues are raised by committees and that everyone who's been on this working group participates in those discussions as well. Even though we didn't come out with solutions out of this working group today, I think we can come up with solutions on these issues of medical records both issues, all three statutes, if we continue to have those discussions throughout the year. And if folks do have proposals, please bring them out to the chairs. I'd be open to them. I believe Rep. Quinn and Rep. O'Day would also be open to hearing those proposals, their solutions on these problems that I think we can solve together.
Okay. And with that, if I could have a motion to adjourn.
So moved.
Second.
Second.
All in favor?
Aye.
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 Okay, we are adjourned and hope you all have an enjoyable